Okay, good afternoon, everyone. Today is May 16th. This is Judge Lopez. I'm going to call the 2 p.m. case, which is Monitronics, call it International Inc. et al. Here on first day hearings. Hope everyone's doing okay. And for those that have not been here before, at least virtually, welcome to Houston. Let me go ahead and take appearances, and why don't I start with counsel for the debtors.
Good morning, Your Honor. This is David Hammerman of Latham & Watkins on behalf of Monitronics International Inc. and its affiliated debtors.
Okay, good afternoon. Let's see. Mr. Ruff, have we unmuted your line? If not, please hit 5-star. I want to make sure I get the United States trustee.
Oh, Your Honor, I've been on.
Perfect.
Your Honor, good afternoon. Jason Ruff from the U.S. Trustee's Office, all unmuted and ready to go.
That sounds great. And I would just announce to parties that if you go to the Southern District of Texas website and you find my link, there is a sign-in sheet for this case for those that won't be speaking that wish to make an appearance. You ask that you make your appearance in that way. Is there anyone else who wishes to make an appearance who will be speaking today? If we've already unmuted your line, great. If not, I'd ask that you please hit 5-star.
Good afternoon, Your Honor. Are you able to hear me?
Just fine.
Thank you, Your Honor. This is Brian Resnick of Davis Polk and Wardwell on behalf of the Ad Hoc Lender Group. I'm here with my colleagues David Schiff and Stephanie Massman, as well as our co-counsel Charlie Beckham and Arsalan Mohammed from Haynes & Boone.
Sounds great. Good to see you, Mr. Resnick. Anyone else wish to make an appearance for today? Alrighty, I've got some folks here. I've got let's see, it's like a 435 number.
Yes.
Yes. Hello.
This is Orrin Xavier.
Hello?
This is Orrin Xavier Flores. Can you hear me, Judge?
Just fine. Good afternoon. All right. Anyone else? All righty. I'll turn it back over to Debtors Counsel. Wait. Before you do this, I'm sorry. I got two more, and then I'm turning it over to you. An 832 number?
Yes. Hello, Your Honor. Can you hear me?
Just fine.
Yes. This is Anthony Barnhart.
Okay. And who are you with? Are you?
I don't know, sir. I got this. My old house I lived at called me this morning and said that something was delivered, and they took pictures of this file. And
maybe just a notice of the bankruptcy filing. You're welcome to participate today. I just ask that you please keep your phone on mute, and if you wish to just hang up, you're certainly welcome to listen in. And if you hang up, there's no need to ask me for permission to be excused, along with anyone else. Is a 605 number?
Okay.
Your Honor, this is Cheryl Bogue with the City of Sioux Falls City Attorney's Office. We would not be speaking. We also received this in the mail, and we are unsure of our connection to this case.
Okay. Thank you. All righty, Mr. Harriman, I'll turn it back over to you.
Okay, thank you. For the record, again, David Hammerman of Latham & Watkins on behalf of the debtors. First, I'd like to thank Your Honor, your staff, and the clerk for accommodating us today. I know there was a flurry of complex cases filed in the last few days, so we apologize for heaping a ton of reading on top of the pile, but we certainly do appreciate it. I'd also like to thank the Office of the United States Trustee, who, as always, engaged constructively with us over the past few days on the relief requested today. I believe all of the proposed orders and related documents reflect the comments from the United States Trustee and other parties in interest, so we're hopeful that, with perhaps one exception, we'll come back to all matters on the agenda for today will be fully consensual.
Okay.
We also saw that Your Honor entered some procedural orders this morning, and we appreciate that as well. A couple of housekeeping items before I begin. We have a number of people present today via video and on the phone that have been integral to the process so far and will play an important role today and in the coming weeks. From the debtors, we have our first day declarant, William Niles, the debtor's Chief Executive Officer. From the debtor's proposed financial advisor, Alvarez and Marçal, we have Andrew Pu. From the debtor's proposed investment banker, PJT Partners, we have Vinit Kothari, Jamie Baird, and Andrew Saketa. From Kroll, the debtor's claims and noticing agent, we have Ben Steele and Alex Orchowski. And in addition, we have Tad Davidson, Ashley Harper, and Brandon Bell from Hunt & Andrews Kurth. And I'm joined also by several colleagues from Latham who you will meet along the way today.
Okay.
Your Honor, we're very proud to report that we're before you today commencing these partially prepackaged cases with the support of the vast majority of our key stakeholders. Through a restructuring support agreement, we now have the support of 100% of our impaired secured lenders and over 2/3 of our shareholders for a comprehensive deleveraging transaction that will right-size the debtor's capital structure and provide the company with a sustainable path forward. Restructuring also contemplates paying unsecured creditors in the ordinary course. The RSA and the plan are the product of very extensive negotiations with the debtor's funded debt lenders and a material portion of their shareholders. And we're very grateful for the hard work of the management team, the parties to the RSA, and their advisors to get us in a position to commence these cases on such a strong footing. Before turning to the agenda today, I'd like to start with just a brief overview of the debtor's business and capital structure, provide some additional context for how we arrived here and how the debtors intend to exit these cases. Monitronics International was incorporated in Texas in 1994, and along with the other debtors is primarily engaged in the business of providing residential and commercial customers with monitored home and business security systems, as well as interactive and home automation services. They're the people on the other end of the phone when your home alarm goes off. As you might imagine, the services the debtors provide are often in life or death situations for those with health, safety, or fire emergencies. And the debtors are one of the largest home security alarm monitoring companies in North America, with customers under contract in all 50 states, the District of Columbia, and Puerto Rico. Debtors generate nearly all their revenue from fees charged to customers under alarm monitoring agreements. Additional revenue is also generated from the sale of alarm systems and related home automation products, as well as from ancillary sources such as field service revenue and contract monitoring services provided to the debtors' dealers. The debtor's business model depends on three principal sales channels, with customers sourced through a dealer channel, home direct channel, and a direct-to-consumer channel. The largest is the dealer channel, and it consists of approximately 150 independent dealers who are typically small businesses that sell and install alarm systems. Dealers don't typically retain the alarm monitoring agreements because of the large upfront investment required to build and efficiently operate monitoring stations and related infrastructure. So the debtors purchase these monitoring agreements or otherwise take over the monitoring function on their behalf. The home direct channel offers professional product installation and sales of security solutions through the debtors' network of field sales representatives. And the third principal sales channel is the direct-to-consumer channel. Under that channel, the debtors advertise online and through other mediums to generate sales leads to obtain subscribers through a trained internal phone sales team. As Your Honor may know, Monitronics has been in this court before. Back in 2018, the debtors began to face challenges as a result of their high debt load and related cash flow constraints. And that culminated in prepackaged Chapter 11 cases filed in this court. That was case number 1933650. It was before Judge Jones. And the debtors emerged from those cases on August 30th, 2019. And while the debtors emerged from those cases with a delevered balance sheet, they continue to face challenges owing in part to their existing business model. In addition to high customer attrition rates, the debtors' business model at the time required significant upfront costs in order to continuously acquire new customer accounts at the pace necessary to sustain operations and service their debt. So starting in 2020, Monitronics implemented material changes to its management team, transformed its business model, and launched a new brand strategy. And in order to remain competitive and ensure long-term stability, the new management team changed their business model to focus on lowering account acquisition costs, reducing risk by enrolling customers with a more stable credit profile, and negotiating more favorable contract terms with their dealers. The debtors also moved away from the highly competitive do-it-yourself alarm security package in favor of a more do-it-for-me approach. While these changes created very positive results and operating cash flows have been strong, the debtors continue to carry a significant funded debt burden, and servicing those obligations has negatively impacted liquidity. In the face of these issues and impending maturities, the debtors explored various options to raise capital to refinance their existing credit facilities and or extend maturities. But at the same time, market conditions began to deteriorate, which has only been further exacerbated by repeated interest rate hikes that have further constrained the debtors' cash flows. And it was against this backdrop that the debtors and their board determined it was in the best interest of their business, as well as all their stakeholders, to explore more holistic alternatives to reduce their leverage and provide a long-term solution to near-term liquidity constraints. Before I turn to the deal that's embodied in the RSA, I just want to provide a brief overview of the debtors' pre-petition capital structure. As of the petition date, the debtors had approximately $1.09 billion in aggregate debt outstanding under their pre-petition credit facilities, which were entered into in connection with the debtors' emergence from the 2019 Chapter 11 cases. This includes a super priority secured revolving and term loan facility with an outstanding balance of approximately $294 million, and an additional secured term loan, which I'll refer to today as the takeback loan, with an outstanding balance of approximately $793 million. After engaging in extensive good faith negotiations with an ad hoc group of certain holders of the takeback loan and certain other key shareholders, the debtors were able to secure support for a comprehensive capital structure solution that's embodied in the Restructuring Support Agreement. That's filed as Exhibit B to the disclosure statement, which is at docket 7, and Exhibit B to the first day declaration, which is at docket number 10. Through the restructuring agreed to under the RSA, the debtors' pro forma total debt will be reduced from approximately $1.09 billion as of the petition date to $600 million upon emergence under a new term loan credit facility. The debtors will also commence an offering of subscription rights to purchase in the aggregate approximately 69% of the total units of new common equity of reorganized Monitronics for an aggregate purchase price of $100 million, and that is fully backstopped. And the debtors will simultaneously commence a debt offering of rights to fund new exit first out loans in the aggregate principal amount of $300 million. The debtors also propose to enter into a DIP facility in an aggregate principal amount of just over $398 million. The proceeds of the DIP facility will be used to repay our outstanding pre-petition super priority facilities and address the debtors' liquidity needs during these cases. Participation in the DIP facility was offered to all holders of the 2019 take-back term loan claims, and the full amount of the DIP was backstopped by members of the ad hoc lender group. And although we're still working through the paperwork, it's my understanding that 100% of the Class 3 take-back lenders will be participating in the DIP facility. My colleague, Mr. Gott, will provide some more details on the DIP and the rights offerings shortly. Finally, we're very pleased to report that the transactions not only contemplate paying all trade creditors in full in the ordinary course, which is a positive step for minimizing the disruption of these cases on the debtor's business, but also provide a meaningful recovery to the debtor's shareholders. Just briefly turning to some process and housekeeping issues, my colleague, Mrs. Taragunis, will walk through the milestones and proposed solicitation schedule in further detail. But at a high level, the debtors are seeking to obtain confirmation of the plan as expeditiously as the court schedule and applicable notice and due process requirements will accommodate. To that end, we've made efforts to ensure the maximum amount of notice possible in today's proceedings. Our claims and noticing agent, Kroll, provided notice of today's hearing and the first day matters as set forth in the affidavit of service filed at docket number 41. The affidavit provides details on the manner and means of service, including by email or available, and also by overnight mail on the parties, including all registered equity holders, and that's all laid out in the affidavit. On May 15th, Kroll forwarded the notice of hearing and agenda, as well as the equity trading motion at docket number 18 to DTC's legal notice system or LENS system for posting. And our understanding is the majority of the debtors' common stockholders hold through nominees who have access to the LENS information and can provide it to the beneficial holders. Additionally, Kroll established a website for these cases, which includes notice of today's hearing and copies of all the first day pleadings. And the company provided notice internally through its normal communication channels. And finally, the company also issued a press release announcing entry into the RSA and the anticipated commencement of these cases. Before I turn the podium over, just a few further housekeeping items. The debtors have filed a witness and exhibit list at docket number 34 The debtors request that exhibits 1 through 15, I believe, be admitted into evidence. This includes multiple declarations. First is the declaration of Mr. Niles, which can be found at docket number 10. Second is the declaration of Mr. Koo, which is at docket number 22. And the third is the declaration of Mr. Kozari at docket number 23. The declaration of Mr. Steele from Kroll has also been filed as Exhibit B to the application to employ Kroll, which was at docket number 5. The declarants are available in the virtual courtroom, so if anyone would like to cross-examine them, otherwise we'd ask that these declarations be admitted into evidence for purposes of today's hearing.
Any objection to the admission of Exhibits 1 through 15 for purposes of today's hearing? I'll need you to hit 5-star if you wish to speak. One party. Hello?
Hello?
Yes.
This is Judge Lopez.
This is Judge Lopez.
Hello, this is Jesus Santos. I just barely got a letter in the mail saying I'd have to join this court case. What's this court case resolving around?
This court case is involving the case of Monitronics. It's a security company, and you are free to participate today. I think you have some connection with the case, either as a customer or in one way or the other. So I would just ask if you wish to participate. You are free to do so. I just ask that you please keep your phone on mute. And if you elect not to participate in the case, you are free to hang up and no need to ask me for permission to be excused. Okay?
Okay.
Thank you. Exhibits 1 through 15 at docket number 34 are admitted. And Mr. Herman, I'll take this opportunity to thank everyone who put in the hard work drafting that and who had a hand in those. I haven't forgotten how hard it is to put one together and the amount of work that goes into it. I will tell the folks that worked on the declaration and obviously the declarants who had to read it and confirm that they were comfortable with the statements in there, that I read every word of them, and I found them to be incredibly helpful and really helped me get up to speed and get really smart on the issues before the court. So I thank everyone. All right, Mr. Hammond, back to you.
Thank you, Your Honor. I'm going to turn it over to my team to continue the rest of the hearing, but before I do, I think Mr. Resnick from Davis Polk would like to make some intro comments.
Sure. Mr. Resnick?
Thank you, Your Honor. Once again, Brian Resnick of Davis Polk and Wardwell on behalf of the Ad Hoc Lender Group. I also want to extend Your Honor in the U.S. Trustee's Office. Feels a little bit like deja vu from yesterday. I know it's been a very busy few days for you all. So, Your Honor, the Ad Hoc Lender Group holds approximately 77% of the 2019 takeback term loan and 36% of the 2019 exit facilities. The Ad Hoc Group fully supports debtors in these Chapter 11 cases, both the relief that's being sought today, the debt facility and everything else, as well as the fully consensual prepackaged plan of reorganization that will be up for hearing in June. This support is evidenced by the fact that our clients have agreed to fully backstop the financing of these Chapter 11 cases, both the DIP and as well as the exit. Just to take a second, Your Honor, in terms of the history, the members of our group have been supporting this company for quite a while, having been lenders since before the 2019 bankruptcy. Because of this, they have an intimate knowledge of the business, the management team, and the home security space more generally. Throughout this relationship, the lenders in the company have been committed to maintaining an ongoing and productive dialogue. Around the fall of last year, the Ad Hoc Group began working closely with the company's executive leadership and the advisors to better understand the issues facing the business and the potential need for additional liquidity and a restructuring transaction to address the company's balance sheet. When it became clear that a global restructuring transaction would be value maximizing, the negotiations among the company and our group, as well as the principal shareholders, progressed, and ultimately the parties executed the Restructuring Support Agreement that you heard about just in April. The RSA signatories now include, as Mr. Hammerman said, 100% of the pre-petition take-back term loan facility and over 70% of the existing shareholders. And since we got the RSA, we've all been hard at work documenting the DIP facility, the plan, and the other definitive documents. Your Honor, we believe this is a very significant achievement. A quick consensual restructuring was not preordained, and the global compromise that's reflected in the RSA and the plan is the result of intense around-the-clock negotiations and very constructive participation of the various stakeholders. I realize the plan is not up for approval today, but the DIP facility is an integral part of the comprehensive set of transactions that we think will fundamentally alter the company's capital structure for the better and ensure that the company has the liquidity that it needs to operate and grow its business. So unless Your Honor has any questions for me, I will hand the podium back over to Latham to continue with the motions on for today.
Okay, thank you. No questions. Let me just see.
So, Ms. Harper.
Alrighty. Before I did, I just wanted to make sure that there was anyone else that wished to make any form of an introduction. Now would be the time before I turn it over to Ms. Harper. Alrighty. And before I forget, I want to thank the Office of the United States Trustee. I know they've read just as much paper as I have over the last few days, and I really appreciate the incredible amount of hard work that they've gone and put into all of these cases. It's much appreciated. So just want to add my appreciation in there as well. Ms. Harper, I'll turn things over to you.
Good afternoon, Your Honor. Ashley Harper, Managers First, Proposed Co-Counsel for the debtors. Can you hear me okay?
Just fine.
Great. Thank you, Your Honor, for accommodating us today. And thank you for entering the first three items on the agenda. So I'll move to agenda item number 4, which is also docket number 4, and that is the debtors' consolidated creditor matrix motion. In this motion, the debtors are seeking 3 categories of relief. The first is authorizing the debtors to file a consolidated creditor matrix and a list of top 30 largest unsecured creditors in lieu of separate mailing matrices and lists for each of the debtors. We believe this relief is consistent with what complex case procedures require. The second category of relief we're seeking is waiving the requirement to file a list of the equity security holders for Monitronics International, Inc. As Mr. Hammerman described, the registered holders are being served with notice for Monitronics International, Inc. The third request that we have, Your Honor, is to authorize the debtors to redact addresses and names of individuals. With respect to these redactions, we believe that redacting both the addresses and the names is appropriate here, given the nature of our industry. We're very sensitive to security and protecting individuals. The consequences of not redacting and something happening to just one person is too high of a risk to take here. We're providing the unredacted version of that list to the U.S. Trustee's Office, and upon request, to parties in interest for calling. So we believe, Your Honor, this process that we've provided and the procedures strike the right balance here. And we've shared this motion with the U.S. Trustee. We don't believe there are any objections to it by any other party. And unless Your Honor has any questions, we request entry of the order.
All right. Does anyone wish to be heard in connection with this motion?
Just real briefly, Your Honor, I will say that with respect to the names, we actually noted our objection, but we also know Your Honor's position on the redaction of names. So just for the record, we'd like to note the objection and that you're going to overrule our objection.
No, it's been really noted, and I appreciate the United States Trustee. They have a job to do, and they filed their objection, and I feel differently. I think Judge Jones and I are consistent on this. We're comfortable with the procedures that are in place, but respect that others may disagree with it. In this instance, I'm going to overrule the United States Trustee's objection. I think it's important to keep these names redacted for the reasons stated in the motion, and I'm going to grant the objection. I'm going to grant the motion, so that is off to docketing.
Thank you, Your Honor. I'm going to pass the virtual podium over to Chris Bocage from Latham.
Good afternoon, Your Honor. Can you hear me okay?
Just fine. Good afternoon.
Thank you. For the record, Christopher Bocage of Latham & Watkins, proposed counsel to the debtors. Your Honor, the next agenda item is at number 5, and it's the debtor's wages motion, which is filed at docket number 11. By this motion, the debtors seek authority to pay amounts related to various pre-petition workforce obligations, including wages, expense reimbursements, and payments related to benefit programs. In addition, the debtors seek to continue severance, retention, and incentive programs as described in the motion. The headline number here is roughly $4 million outstanding on account of pre-petition workforce obligations. Your Honor, this motion is crucial. We need to send a clear message to the employees. There cannot be a Monitronics business without employees, and they deserve finality and certainty. We obviously previewed our papers with the U.S. trustee and other parties in interest. One thing to note is that since filing the motion, we've agreed to make a change to the order at paragraph 3. We filed a revised order at docket number 46. Essentially, we clarified that the debtors need only provide notice of material changes to workforce programs. And one last point, to get ahead of any questions on the cap, there are 6 employees with amounts exceeding the statutory cap. We provided information about them to the U.S. trustee. However, we are still seeking authority to pay these amounts in the ordinary course. This is a now pay case, and we would only be affecting timing and not whether these employees are getting paid. And unless Your Honor has any questions, we would kindly request entry of the proposed revised order at docket number 46.
Anyone wish to be heard in connection with this motion?
Your Honor, I just want to, again, Jason Orr for the U.S. Trustee's Office, just want to say thank you to the debtors in providing us the information necessary just to help work through this motion. With respect to the payment of the employees that are, I think there were 6 of them that were over the statutory caps, normally we would request that the relief be interim and then subject to no objections then. But our understanding is that those payments would not be made until, are not due to be paid, at least until later on in these cases. So I just want to make sure that it's clear that it's just under the facts and circumstances of this case and this case alone, given that we're a pre-pack and that creditors are intended to be paid 100 cents on the dollar here. Just wanted to give the context for why it is that we wouldn't raise our normal objection.
No, I find that incredibly helpful. Thank you very much, Mr. Rubin. And I agree with you. I would probably push it out as well. If someone was over the cap, just to make sure that we got notice and an opportunity to object to it. Someone was over the cap, but this is a pre-pack case, and I do appreciate the reasonableness here. So I have signed the order at docket 46. It looked good to me, and so it's approved.
Thank you, Your Honor. Up next is the debtor's cash management motion, which is at docket number 12. This is a pretty standard cash management motion. The debtors are seeking to maintain the system as is with the bank accounts and the existing business forms, as well as pay certain pre-petition bank fees and continue intercompany transactions among debtors. We attached a cash flow schematic at docket 12-1, and as you can see, it's fairly simple, 13 accounts with 4 different banks. Again, we previewed the papers with the U.S. trustee who has agreed to a 45-day extension for the debtors to demonstrate compliance with 345B, with option to seek additional extensions. Again, unless Your Honor has any questions for me, we would kindly request entry of the proposed interim order, which is at docket 12-3.
All right. Anyone wish to be heard in connection with the cash management motion? I do know that it's an interim motion. Let's see. So I do find that cash management motions are very, this is procedural, like allow the debtor to ease into the Chapter 11 process without material disruption to their cash management system. And I do know that there's an extension of the 345 period, so that's customary here, and I appreciate all the parties working together. Mr. Bokash, I think I have to plug in a final hearing date. What date did you have in mind?
I believe we would do the same date as the confirmation and DIP, the second day hearing. I'm not sure if that's been set. I believe it's June 26th, but
yeah,
somebody else on the line can keep me honest.
It is June 26th. I just wanted to see if you knew it. That was the little quiz for the day. I just wanted to keep you on your toes. I'm going to set it for June 26th at 1 p.m. And I've got to set an objection deadline. Looks like, so June 26th, June 6th, 5 p.m. will be, I'm going to write this down because I always forget. June 26th, 1 p.m. hearing on this. June 6th, 5 p.m. At the objection deadline. And I'm going to sign this and send this off to docketing. Alrighty, it's done.
Thank you very much. Next up is the debtor's dealer motion, which is filed at docket number 13. This is a bespoke motion. The debtors seek authority to pay undisputed claims of dealers and representatives. And when I speak of representatives here, I'm referring to sales representatives and technicians. The dealers and the representatives are crucial to the debtor's business because this is how the debtors acquire new customers. In 2022 alone, the dealers and reps accounted for over 75% of added new customers. As described in the motion, as it pertains to dealers, there are two ways in which they can generate customers for the debtors. The first is they can generate a contract directly with a customer and then assign that contract to the debtors, or they can originate customer contracts on behalf of the debtors. All of this is in exchange for fees that we've described in the motion. It's a bit different for the sales reps and the technicians. These guys go door to door to generate contracts on behalf of the debtors directly. If a contract is executed, then a technician is either on standby or available on short notice to install the product. And again, all of this is in exchange for fees that we've described in the motion. In total, at most, there is approximately $12 million on account of precision dealer and representative claims. Those claims would be unimpaired and would receive full payment under the plan. The purpose here is to make sure that we maintain and protect these relationships both during the case and after the bankruptcy. The debtors do not want to lose the dealer base or the sales rep through this process. Obviously, and once again, we've shared our papers with the U.S. trustee and parties in the interest. And unless you have any questions for me, we would respectfully request entry of the proposed order, which is at docket 13-1.
Anyone wish to be heard in connection with the dealer motion? I'll just make a global note. For all the motions that I'll consider today, and I've seen them on the agenda, I'm going to find that there's been proper notice of today's hearing. Clearly, there are parties who have appeared today, and that's comforting. I'm also going to find proper service, which is also evident today. That is seeking authority to continue essentially their practices with their dealers, and this is what helps generate funds and is a sound exercise of their business judgment, which is the standard. And based upon the declarations that have been filed, I do find that it is appropriate under the circumstances to continue to do so, and for sound business reasons. Therefore, business judgment is satisfied, and I'll grant the motion. Where do we go next?
Thank you very much, Your Honor. That's it for me today. I will cede the virtual podium to my colleague, Dennis Argyle. Thank you, Your Honor.
Y'all are incredibly organized with who pops off and who pops on. It's quite impressive. Thank you.
Thank you.
Good afternoon, Your Honor. Dennis Yergi, Latham & Watkins on behalf of the debtor. Your Honor, my presentation this afternoon will cover agenda items 8 through 12, which I would propose to take in order unless the court has a different preference.
Nope.
Your Honor, the first motion is agenda item 8, debtor's utilities motion, which can be found at docket number 14. By this motion, debtors seek approval of the proposed adequate assurance procedures, including the establishment of a segregated bank account for the benefit of the utility providers. The debtors have calculated their average monthly cost of utility services for the past year and propose to deposit half that amount into a segregated account. The amounts proposed for each of the utility providers is set forth in Exhibit A to the proposed order. Your Honor, this motion also seeks to implement customary notice procedures or procedures for utility providers to request additional adequate assurance and sets forth a process to resolve disputes regarding such requests, if any. The proposed form of order incorporates comments from the United States trustee, and unless Your Honor has any questions, the debtors request that the court enter the order.
I reviewed this. This is customary, and I appreciate it. I can tell the United States trustee gave comments to this, so I'm comfortable with where we are. It's customary in our district, the proposed form of order, and I'm signing it just now.
Thank you, Your Honor. Next up is
I will tell you, Mr. Ergate, there's a colleague of mine who was on the complex panel. He would have grilled you on 366, but I'm just not that kind of guy. You would have had a 10-minute conversation on the uses of utilities in there. I'm nicer. In some respects. We'll see. We'll see how it goes.
Thank you, Your Honor. Next up is the tax motion, which is agenda item number 9 and can be found at docket number 15. The tax motion seeks entry of an order authorizing the debtors to pay their pre-petition taxes and fees in the ordinary course, as well as any taxes and fees that come due during these proceedings, accrue during these proceedings. As a general matter, the taxes and fees include sales, income, personal property, and franchise taxes paid to state and local authorities in all 50 states. Debtors also pay various licensing and permitting fees, which include special permits the debtors maintain in order to provide alarm monitoring services to their customers. Although the debtors believe they are substantially current in the payment of taxes, certain amounts attributable to the pre-petition period have not yet come due. In total, the debtors estimate that $4.8 million in taxes have accrued as of the petition date. As reflected in the motion, a large portion of that, $3.7 million, is for sales taxes collected on behalf of the taxing authorities. Your Honor, the failure to timely pay the taxes could result in penalties, potential liens on the debtor's assets, among other consequences to the detriment of the estate. The proposed order, as with the utilities order, reflects comments from the U.S. trustee and the ad hoc lender group, and unless Your Honor has any questions, we would also request the court enter the order.
You can pay your taxes. I've signed the order.
Thank you, Your Honor. Next up is the debtor's insurance motion, which is agenda item number 10 and can be found at docket number 16. By the insurance motion, the debtors seek authority to continue to maintain their insurance coverage and surety bonds and to pay all premiums, fees, and other obligations under the existing policies and bonds. This also includes fees paid to the debtor's insurance broker. Debtors further request authority to revise, extend, or replace their insurance coverage or bonds as needed in their business judgment. In general, Your Honor, the premiums under the policies are paid upfront on an annual basis. While the debtors do not expect the policies to renew during these cases, the debtors will have payments coming due under a premium financing arrangement, as well as certain premium payments due to one of the debtors' insurers. In total, the payments under the premium financing arrangement and the premium payments to the insurer total $436,000, which will come due during these proceedings. Similarly, Your Honor, the bond premiums are typically paid upfront on an annual basis, and the debtors are not aware of any pre-petition amounts that are outstanding with respect to those. Overall, the debtors believe that the coverage and bonding programs are typical and what would be expected from a company in the debtors industry. And as with the other motions, the proposed order reflects comments from the U.S. trustee and ad hoc lender group. And if Your Honor doesn't have any questions, the debtors will request that the court enter the order.
I've entered the order. Well, I will now, I should say. Insurance is important. It's required. The United States trustee finds maintenance of insurance incredibly important, maintaining the existing policies and procedure. I find it incredibly important. It preserves value. It's for the benefit of the estate. It is a sound exercise of the business judgment to pay for it now.
Thank you, Your Honor. Next is agenda item number 11, the debtor's pre-petition trade motion, which can be found at docket number 17. Under this motion, the debtors seek authority to pay pre-petition trade creditors in the ordinary course during these cases, and on the condition that such vendors continue to do business with the debtors on customary terms. The different types of creditors are summarized in a chart we've included in Exhibit A to the order, which also provides a breakdown of estimated pre-petition amounts. In general, Your Honor, these vendors include suppliers of alarm monitoring equipment, monitoring services, customer software vendors, IT, and various service providers needed to maintain the debtor's facilities. These also include payments made over time under purchase agreements relating to the purchase or sale of monitoring accounts with other companies in the industry. Your Honor, debtors believe that the payments to these vendors is necessary to maintain a business-as-usual atmosphere during these cases, and most importantly, avoid any disruption to customer services. As has been noted, the plan contemplates that unsecured creditors will be unimpaired, so the relief requested is really one of timing and trying to bridge the gap from now to emergence for those vendors that are critical to the business. The form of order reflects comments from the U.S. trustee as well as the ad hoc lender group. And for this one, I would like to just flag two changes we incorporated based on the U.S. trustee's comments. First, while the debtors do not intend to pay insiders by this motion, the order does clarify that any such payments would be upon notice with the court with an opportunity to object. The second comment we incorporated was an aggregate cap on pre-petition trade to be paid by the motion, requiring the debtors to file a notice with the court if they expect to exceed that cap with at least 2 business days notice. With that, Your Honor, unless the court has any questions, the debtors would request that the proposed order be entered.
Okay. I want to make sure I'm just looking at the. No, I know when Mr. Ruff, his hands have been in on a pleading. I can tell U.S. trustee comments from the Southern District of Texas, so I appreciate it. And they've been working really hard, and I really appreciate all the hard work that they've done into this. Before the court is a motion to approve payment of pre-petition claims of certain creditors in the ordinary course of business. The court, this one I take a hard look at, usually on a first day, because, just case was filed on 2 days' notice, and we're having a hearing, and so every case has to be considered on its own sets of facts and circumstances. And here we have a pre-pack and the trade is going to be unimpaired. Payments are going to be made in the ordinary course of business. There are appropriate guardrails in the order now, with the opportunity for the debtor to come back and ask for more, but kind of essentially what's being represented to the court in terms of the buckets. That's what I'm authorizing, and so I like the way the order reads. I think it makes sense to me. I think it's a sound exercise of the debtor's business judgment. Certainly will help the debtor in this instance. So I'm going to grant the motion.
Thank you, Your Honor.
All righty.
Final motion, Your Honor, for my presentation is agenda item 12, the debtor's equity trading motion, which can be found at docket number 18. By this motion, the debtors seek approval of procedures to monitor and, if necessary, object to actions by material shareholders that could impair the debtor's tax attributes. In particular, shareholders that meet the relevant ownership thresholds would be required to notify the debtors of their intention to acquire or dispose of stock, or the taking of a worthless stock deduction. The debtors estimate that as of December of last year, they had approximately $573 million of federal NOLs and $163 million in business interest expenses. While the debtors continue to evaluate the extent to which these attributes remain available in the context of this plan, they are potentially highly valuable estate assets. We believe the relief requested is fundamentally procedural in nature and really intended to give the debtors an opportunity to evaluate the tax consequences of proposed actions and, if necessary, seek relief to preserve assets of the estate. If Your Honor does not have any questions, the debtors would request entry of the order establishing the notice procedures.
I read the procedures. They're customary in our district, and it's important to preserve the tax attributes. It's a sound exercise of the debtor's business judgment. The code authorizes me to allow this to occur, so I am comfortable with the notice procedures here. And I did review the order and the attachment to the order. I read them carefully, and I'm comfortable. So I'm going to sign the order.
Thank you, Your Honor. With that, Your Honor, I will cede the podium to my colleague, Ms. Saragunis, who will handle the next agenda item.
But before you go, and I just wanted to just note to all these folks who presented today, a lot of your partners are probably tired of me saying this, but I say this for your benefit, or at least I think you all did a fantastic job today. Everyone presenting, it shows me that you took really seriously. A lot of the relief that's requested can be considered, routine in large Chapter 11 cases, but to the individual who, is worried about whether they're going to receive a paycheck, coming into court and having the assurance that they're going to maintain their health benefits for themselves and their loved ones is incredibly important. And I've been in offices where people were scared, and I've seen that look on their face. And so taking it seriously, taking the fact that the debtor can maintain its insurance, to make sure that the lights stay on, they all seem really routine, but I think you're also sending me a message about how you take, and everyone took the court process very seriously. I came from, I'm not ancient, but I did come from an era where, young associates would work on motions, and you were happy to get a dial-in number that you could listen into the hearing and at least understood what happening. And then when you were trusted a little bit more, they brought you down and you sat in the back of the courtroom, but you were just happy there. You were happy to just bring a box with binders. And as you got older, then they let you sit at the table. And at some point, a couple of years in, maybe 5, 6, 7 years in, you would speak. And just the fact that y'all have the opportunity to present, I want to thank everyone at Latham for giving you the opportunity to do so. I think it's important. But I'm really happy that you took it seriously. I would have been very disappointed if someone would have just ran through a well-rehearsed speech without any thought behind it. Folks like me fought really hard to try to make sure that young lawyers had the opportunity to be able to present. And so I thank you for taking it seriously, but treat everything that you do with the level of care. And I'm speaking to everyone who presented. Take the level of care that you did today, preparing for today, and treat it for everything. Your reputation starts today here in front of me, and I look forward to a continued you appearing in front of me, all of you, and I expect nothing but excellence, because excellence is just what you do. It's just not because you're in front of me, but it's just becomes second nature to who you are. And every time that you present, the court can trust what you say, because I know the amount of dedication and care that you put into it, and I hope it comes across the level of detail in preparation that I put into it as well, because I want you to respect at the same time what the court is doing. So I'm sitting up late reading everything that you're writing so that it doesn't feel like it went to waste. I want you to know that the hearing goes smoothly because I've really read everything, and I know what you're asking for, and I know what your presentation matches that. So anyway, probably putting everyone to sleep now, but it's important to me that I communicate that to you, and I wish you all the best. I wish everyone all their best in their careers.
Thank you, Your Honor. And the comment.
Thank you, Your Honor.
Yeah.
Thank you. All righty. On to the next thing. Sorry.
Good afternoon, Your Honor. Helena Sirgunis from Latham & Watkins on behalf of the debtors, and thank you for those very kind and insightful comments. I know the whole debtors team appreciates it, so we appreciate that, Your Honor. I am going to take the solicitation procedures motion today. Before we do that, I just wanted to direct Your Honor's attention to the plan and disclosure statement that we filed on the docket yesterday. There is one version of the plan, that's docket number 8, and then there were 2 versions of the disclosure statement filed. Those are dockets number 6 and 7, respectively. We also filed a notice of the revised disclosure statement with red line pages at docket number 9, intended to show the changes between the 2 disclosure statement drafts. I'll just describe those changes overall. There's 2 buckets. The red line was first the disclosure statement, was first updated to show that 100% of the takeback lenders, which is the entirety of Class 3, have now signed on to the RSA and are consenting lenders. Okay, great. We've made corresponding date changes throughout to match that. In addition, we made a clarifying change at the outset of the disclosure statement just to make clear that recovery to equity for those holders of equity interests that opt into the equity election is subject to dilution by the post-emergence incentive plan. Now, that was clear elsewhere in the plan and the disclosure statement, but given that this is going to be the draft that goes out to solicit Class 7, we wanted to make sure it was clear at the outset as well. And then the remaining changes throughout were clean up that track, those 2 categories of changes. And just to be very clear for the record, in terms of process, we had served the original disclosure statement on the holders of Class 3, and we proposed serving the revised disclosure statement on the holders of Class 7 in connection with post-petition solicitation. So moving on to the solicitation procedures motion, that's docket number 19 and agenda number 13. I will go through each of the items of relief that we're seeking today, but if it's helpful for Your Honor's reference, pages 3, 4, and 5 include the relevant proposed dates and a list of the forms of notices and ballots that I'm going to walk through today. And before I get into the specific relief, I'll note that the United States trustee has seen a draft of this motion. He had one comment to add some language clarifying in certain of the notices that for holders of equity interests who opt out of the releases, this will not change their treatment under the plan, and we've added that in the respective notices. So let me start with the combined hearing and notice. We're seeking court approval of a combined hearing date to approve the disclosure statement on a final basis and to confirm the plan, which is set for as Your Honor noted earlier, June 26th at 1 p.m. Central, which is a date we've confirmed is available with your chambers. If Your Honor is inclined to give us that date for the confirmation hearing, we would seek to establish an objection deadline for objections to the plan and final approval of the disclosure statement on June 16th at 4 p.m. Central. And then we would also ask that the debtors and other parties in support of the plan have an opportunity to file briefing and support on or before June 22nd at 4 p.m. Central. In our solicitation procedures, we proposed serving this combined hearing notice, which is attached as Exhibit 1 to the order, which would provide notice of the hearing date, the objection deadline I just described, and then also provide notice of the commencement of the case, key provisions of the plan, including releases, and then treatment of executory contracts and unexpired leases. So all of that would be covered in that notice. We would propose to serve it on everyone on the creditor matrix, which would include contract and lease counterparties. We did have a narrow carve-out for employees unless they hold equity and are entitled to vote, and independent contractors of the debtors. As Mr. Hammerman described in his opening remarks, those folks, the employees had received notice internally from the company. I understand there was a town hall as well. And both employees and independent contractors aren't going to be impaired under the relief that we were seeking, either in the wages motion or the dealer motion. So we propose that limited carve-out is appropriate under the circumstances. In terms of timing, we would serve this notice within 3 business days of the entry of the solicitation procedures order. If that were entered today, that would put us at the 19th, and it would give parties approximately 28 days notice of the objection deadline. We'd also supplement that with a publication notice, which would track the form of the combined notice, and we propose filing that in USA Today on or before June 12th. Moving on to the pre-petition solicitation process. So we have 2 impaired classes under this plan, Class 3, the take-back lenders, and Class 7, holders of equity interest in Monitronics. This is a straddle pre-pack, so we've initiated the pre-petition solicitation process as to Class 3 only, and seeking relief to initiate the solicitation as to Class 7 post-petition. And importantly, the debtors only solicited pre-petition as to eligible holders to ensure compliance with security laws on a pre-petition basis. We do believe that all holders in Class 3 would constitute eligible holders. However, we've included in each ballot that was sent out to that class a certification where they indicate that they meet those requirements. The voting record date for that class was set for May 2nd. We commenced solicitation on May 9th and completed it on May 10th. Certificates of service from the debtor's solicitation agent reflecting that process were filed, I think actually at the time of the start of this hearing, at docket number 58. In terms of what was served, we had solicitation packages, they had the disclosure statement, the plan, the Class 3 ballot, a form of which is attached as Exhibit 5A to the order, and we also included the Class 3 equity registration form, which is attached as Exhibit 2 to the order. This is required to be filled out by holders of claims in Class 3 in order for them to get their equity distributions under the plan. As of today's date, Your Honor, approximately 91% in amount and 69% in number of Class 3 have accepted the plan with no rejections. And as previously has been mentioned, we have support from the entirety of Class 3 under the RSA to support the plan on a contractual basis. Moving on to post-petition solicitation, we are seeking approval to solicit holders of equity interest in Class 7 on a post-petition basis. We would propose setting the voting record date as of the petition date, May 15th, with solicitation anticipated to begin, assuming the order would be entered today, that would start on May 19th, on or around May 19th. The voting deadline is the same for both classes. It would be June 16th, 2023. So assuming we started solicitation on the timeline in the procedures, that would give folks in Class 7 approximately 28 days notice and opportunity to vote. The solicitation packages here similarly include the disclosure statement with plan and related exhibits, a cover letter, and the respective ballots, the cover letter is Exhibit 6 to the proposed order, and the ballots are Exhibit 5 to the proposed order. And just very briefly, there are 3 forms of Class 7 ballots. There's a registered holder ballot that goes directly to folks, registered holders of equity. There are beneficial owner ballots and master ballots that for holders who hold their position through nominees. Each nominee would be provided with a Class 7 solicitation package that included sufficient beneficial owner ballots and a Class 7 master ballot. And then that nominee would have the opportunity to either choose to pre-validate those ballots and have beneficial owners return them directly to our solicitation agent, or alternatively request beneficial owners send back their ballots directly to the nominee. The nominee would compile on a master ballot and send back to the solicitation agent in advance of the voting deadline. Separate from the solicitation process, but on a similar timeline, is the equity election and equity registration form we have for Class 7. That is attached as Exhibit 3 to the proposed order. Holders in Class 7 have the option to either receive a cash distribution under the plan, or if they timely elect, they can receive an alternative equity distribution. So in order to validly elect, they would have to fill out and return this form on or before the equity election deadline, which is the same as the voting deadline, June 16th. If they don't validly make the election or timely submit the election and registration form, they would then just receive their default recovery from the cash pool in lieu of equity. And then finally, from the notice bucket, we have a notice of non-voting status and opt-out form that's attached as Exhibit 4 to the order. That's going to go out to all non-affiliate holders of claims and equity interests who are in non-voting classes. And this will provide them with notices of the releases under the plan and instructions on how to validly opt out. Again, the deadline here to return it would be the voting deadline. So unless Your Honor has any questions on solicitation procedures, I can quickly move to the disclosure statement approval.
You can continue.
Thank you. We are also seeking under the solicitation procedures motion conditional unlimited approval of the disclosure statement for the purpose of initiating post-petition solicitation for Class 7. The proposed order makes it very clear that no parties are going to be prejudiced by this relief. Everyone will reserve their rights to object to final approval of the disclosure statement at the combined hearing. And in addition, our motion also seeks relief with respect to the 341 meeting and the SOFAs and schedules. Specifically, we'd ask the court to extend the timing for the 341 meeting to be convened and the SOFA and schedules to be filed to July 15th, provided that if we have a plan confirmed on or before July 14th, the 341 meeting and the requirement to file SOFAs and schedules would both be waived. With that, Your Honor, I'm happy to answer any questions that you have on any of that relief. Otherwise, I would ask that the court please enter the proposed form of order attached to the solicitation motion.
Just ask, does anyone wish to be heard in connection with this motion? Okay, before the court is a motion, what we call the solicitation and disclosure statement related relief motion filed at docket number 19. I've been informed that there's been proper notice of today's hearing and in service of the motion. The relief requested is very customary in prepacks and including straddle prepacks, which is what we have here. First, there's a request for scheduling a combined hearing on final approval of the disclosure statement and confirmation of the plan. I do find that the court has had opportunity to review the original plan filed at 7, the revised at 8, and whoever put the red line together, I really appreciate it because it allowed me to quickly determine the changes, the additional changes, which were all positive. I do find on a preliminary basis that there's more than adequate information there, and so I see no issues there. I do note that the bankruptcy rules 2002 and 3017 usually require 28 days notice for filing objections to disclosure statements in the plan. The court does have the ability to shorten, but at least the court's lawyer math knows that that's not an issue here. There's been more time presented. I do have an opportunity to review the proposed solicitation procedures and the form of the solicitation materials, the deadlines that are requested, and the forms of ballots that are here. I had a chance to look at all of that very carefully, and I do find that they're customary and appropriate, and they are approved. I approve the procedures. I approve the form of the materials, and the proposed dates, the voting record date, the voting deadline for each class, and the procedures for non-solicitation and non-voting classes I also find appropriate, and I will preliminarily approve the disclosure statement so that that it can solicit, and everybody's rights are reserved for final objections at the appropriate date. So all that being said, is I've reviewed the proposed order, and again, I do appreciate that it's all in one place too, all in one order, so that I would essentially ruin this if I had to put this together and put together PDFs, but someone did this for me, and I've reviewed it, and it looks good, and I'm signing the order at 19.
Great. Thank you so much, Your Honor.
All right.
Now I will hand it off to, I see my colleague Jason Gott, so I will hand it to him for the DIP and the rights offering procedures.
All righty. Mr. Gott, good afternoon.
Good afternoon, Your Honor. Can you hear me okay?
Just fine.
Great. For the record, Jason Gott from Latham & Watkins on behalf of the debtors. I've got two topics today for the court, the rights offering and the DIP facility. I'm going to start with the rights offering, number 14 on the agenda, and it was filed at docket number 20. So by this motion, the debtors are seeking approval of rights offering procedures and the related subscription form that are attached to the motion. This is, at this point, a purely procedural motion, but it is an important one as it sets the company up for a successful emergence and an appropriate capital structure after emerging. The rights offering itself has two components, or you could think of it as two different offerings if you prefer. First, there is a debt rights offering where the take-back lenders will have the opportunity to fund a pro rata share of new exit first-out loans in the total approximate amount of $301 million. The lenders can either fund that with new money or they can pay their subscription price with tranche A DIP loans. And we'll come back to the DIP and how that fits into the picture after we get through this motion. But there's also a fallback provision in our DIP documents that if a DIP lender doesn't subscribe into the debt rights offering for whatever reason, their tranche A DIP loans will automatically roll over into new exit first out loans. The second piece of the offering is an equity rights offering. The take-back lenders there can purchase discounted LLC units in the reorganized company for a total purchase price equal to $100 million. So, and when those units are issued, they'll total up to about 69% of the LLC units, subject to dilution as provided in the plan. Similar to the debt rights offering and the tranche A DIP loans there, the DIP lenders in the equity offering can apply their tranche B DIP claims in order to pay their subscription price. I'll also note, as Mr. Hammerman noted at the top, that the equity offering is fully backstopped by the initial lenders who signed the RSA. We are not seeking approval of that backstop agreement here today, but that is something that will come up in connection with confirmation when we get there. Turning to the mechanics and the timing of the procedures, the debtors intend to use Kroll as their subscription agent. The record date for holders in the offering will be June 9th, and subscriptions will be due June 16th. Now, I'll note we do expect to do a sort of soft launch in the near term, so that anyone among the lender group who wants to, get their subscription taken care of can do so. But the reality is the lenders also wanted to have a trading window post-petition to allow sufficient time for trades to settle before that record date. So that's why we've opted to set the record date at June 9th. We still think everyone will have plenty of time to properly exercise their rights. And then after the June 16th subscription deadline, we'll have our June 26th confirmation hearing, and then we plan to emerge by the end of June, as you heard. I'll note we work closely with our ad hoc lender group to make sure these procedures and forms were both as comprehensive as possible and as clear as possible. And of course, it helps here that we have 100% of those who will be receiving these rights under the plan. They're all signed up to the RSA, so the communication channels should be open and pretty straightforward. We believe that entry of the order will give clarity and certainty to this process, and that will redound to the benefit of all parties here. So unless Your Honor has any questions, we would ask that the proposed order at docket 20-1 be entered.
Anyone wish to be heard in connection with the motion? Okay. For the court is a motion to approve the procedures related to the rights offering. The court has reviewed the procedures, notes that no party is objecting, including key stakeholders in this case, and this is a straddle pre-pack, so I'm comfortable with proceeding with those procedures today. Again, everyone's rights are reserved as to whether there should be final approval of the rights offering. That's another discussion for another day. Today is just whether the debtor can begin the process of seeking so that it can show up on plan confirmation on that day, and it will help the debtor. And it's a necessary part of the plan confirmation process. So I view this really as I really view this as a 363 issue. I know folks like to cite 105, but I'd like to give 105 some teeth, but it certainly has 105 as well. The court can certainly authorize this, which is in furtherance of the plan. So I'm going to sign the order. I've reviewed the proposed form of order, and I'm going to sign it.
Great. Thank you, Your Honor. So the next and final item on the agenda is filed at docket number 21, the debtor's post-petition financing motion. So for this motion and for this presentation, I'll be relying on the declarations of William Niles, Vinit Kathari, and Andrew Koo, all of which Your Honor has already admitted into evidence. And I'll also rely on the plan confirmation order from the debtor's 2019 Chapter 11 cases. It's Exhibit 15 on our witness and exhibit list, which likewise has been admitted into evidence. On the DIP, I want to start by reiterating our collective appreciation for the productive engagement from Mr. Ruff in the U.S. Trustee's office. My understanding is that we have one open issue on the DIP, which I'll come back to in the last bit of my presentation. I want to start, though, by spending a couple minutes on the DIP structure and how it ties into our overall restructuring. Our total DIP facility checks in at just under $400 million, $398.6 million to be exact. We're asking for approval of the full amount under the interim order. The loans are set up in two tranches. Tranche A is $298.6 million, and Tranche B is $100 million on the dot. Tranche B is all new money, and Tranche A is almost all new money, other than a small slug that represents upfront fees being paid to the DIP lenders in kind in the form of tranche A loans. The loans, both tranche A and tranche B, are all pari passu. They have the same liens. And that might lead one to ask why the tranche A, tranche B structure. And that's because the two tranches they're really set up to mirror the offerings that we're doing on the back end that we just talked about. The $301 million of new debt being offered at the end of the case will take out tranche A of the DIP, and the $100 million of new equity being offered at the end of the case is essentially the takeout of tranche B of the DIP. And so what's hopefully evident from this unique specific structure is that this DIP facility is not just a means to an end. It is a very substantive component of the overall restructuring. This is the point in time when the new money is coming into the company. And the transactions that we'll conduct at emergence are really a continuation of the overall recapitalization that's being started with this DIP. So that's the overall funding structure. And to my mind, the other real fundamentals here are where's the money coming from and where's it going to? It's coming from the 2019 takeback lenders. And as you've heard, all 100% are signed up to participate as DIP lenders. They will fund the DIP loans pro rata based on their 2019 takeback loan holdings. At least that's the expectation. And I'll say we're very grateful for that participation and support from our lender group. The proceeds of the loans are going to be used in 4 different ways. First, there's a cash backstop fee going to the ad hoc group of lenders who committed to funding this DIP entirely before it was rolled out to the other lenders. Second use of funds is approximately $297 million being used to pay off the super senior 2019 exit facilities. The third use is that we're going to cash collateralize a $600,000 letter of credit that's currently outstanding under the 2019 facility that we're going to refinance. And by doing that, we can dispense with having to go out and find a new LC to replace that one. We can just leave the existing one in place. The fourth use, and frankly the most important use, is that there will be about $65 million of cash ultimately hitting the debtor's balance sheet for operations and for funding the cost of these cases. Now, it's been a while since the company has had a cash balance that it would view as its sort of comfortable operating baseline without having to sweat all the inflows and the outflows. So this funding gets the company to that more comfortable place. It also then adequately funds these cases based on how we're expecting them to go. And it's also projected to leave the company above that baseline liquidity level after emergence. So with all that laid out, I'll pause to ask if Your Honor has any questions on the background before getting into the argument proper.
You can go into argument.
Right, thank you, Your Honor. We've got 5 primary topics for the argument, and I'll get through them quickly. The first is the need for the financing.
Well, why don't you tell me what's the outstanding issue? Why don't we get to that?
Certainly, happy to. So the outstanding issue, Your Honor, is that our proposed interim order provides for the indefeasible refinancing of the 2019 exit facilities, which effectively takes those facilities outside the reach of potential challenges.
And who's the objecting party?
So we understand the United States trustee intends to object to that proposal.
That makes sense. I tell you what I'd like, because I need to hear from at least someone from PJT and someone from A&M, and I want to just ask them a couple of questions. Our declarants are here. I just want to hear from them, and they can appear by phone if they have to. Their testimony's already in. Mr. Cothray or Mr.
Your
Koo?
Honor. Yeah, just give us a moment. We're good.
You got it. Thank you very much. Appreciate it. Okay. Who is before me?
This is Andrew Koo from Alberta Marcel.
Mr. Koo, want to ask you. I read your declaration, and I just want to understand it. But tell me in your own words. Tell me why you think this is in the best interest of the estate to enter into this dip at this time.
Yes, Your Honor.
I'm hearing some background noise. I just ask everyone to please put your phone on mute. I want to make sure I can hear Mr. Koo carefully. Thank you.
Thank you, Your Honor. So, as previously mentioned, the company has been operating under a constrained capital structure before this case. The company is roughly about a $500 million, $250 million EBITDA business, and the minimum operating liquidity for business such as this is probably somewhere in the $40 to $50 million range. The company has therefore been operating very constrained, which has helped constrain its operations. I think this dip is necessary for the company in order to not only take care of the existing exit facility, but also fund the working capital and general operating needs of the business. Additionally, the dip will provide a message to its customers and its dealer base that is on strong financial ground to be able to continue its business in normal course.
You think it would hurt the company to push a portion of this to a final?
By that you mean a portion of the dip to a final?
Mm-hmm. Or a portion of the refinance of the full takeout to a final? I think that's what the United States trustee is going to object to, right? And so it's we might as well ask the questions that you're going to get. Yeah. So I want to hear from you. Tell me.
I believe it would be less efficient, Your Honor.
What do you mean by that?
I believe that as I mentioned, the company probably needs about $40 to $50 million in liquidity. The budget, the dip financing right now would provide it somewhere around $65 million of funds coming in. We also believe there is some risk to the receipts of the business, given the announcement of the bankruptcy, which might disrupt cash receipts coming in. So we believe the additional funding, the additional funds that the dip provides at this time is necessary.
Thank you. Mr. Rupp, do you have any questions for Mr. Koo?
Yes, I do. Good afternoon. I'm Jason Rupp, the U.S. Trustee's Office. How does the repayment of pre-petition amount help the debtor's post-petition liquidity situation between now and, let's say, a final hearing?
I would defer to Vinit Kothari from TJT to answer that, as he's been more involved in discussions with the various creditors.
I have no further questions for this witness.
Okay. Thank you. Thank you very much. Mr. Kothari, are you around?
Thank you.
Mr. Kothari, and I would note from Mr. Kothari, your declarations are in, and so I'm considering you under oath for purposes of this. I want you to tell me if this is the best deal on the table. I'll ask you that first. Is this the best financing package that you are aware of now?
Yes, Your Honor. This is the best financing package that is on the table right now.
Can you tell me? I read a little bit I read a little bit in the declaration about the process. Can you tell me how, before the bankruptcy case, just about the process that PJT ran to solicit and to see if there was interest, and how you ultimately arrived at as the best proposal, in your opinion?
Yes, Your Honor. So after extensive negotiations with the ad hoc group of lenders around a comprehensive restructuring, through which
being implemented by the DIP as well as the plan of reorganization of the package deal, we arrived at terms for that DIP facility. Upon understanding what those terms were, we, along with the debtors, put together a list of approximately 16 parties that we wanted to reach out to in the market to understand if there was a DIP financing available on better terms for the debtors. Given the structure of the pre-petition capital structure, we, and some of the challenges around the pre-petition capital structure as it relates to the super priority takeback, the super priority term loan as well as the revolver, having first liens as well as the takeback term loan being subordinated but also having first lien, it would be, it was our understanding, it may be challenging to raise such DIP financing. However, we reached out to approximately 16 parties in an effort to seek interest in a DIP, either on a junior basis, either on a senior basis, and an unsecured basis. Through that outreach, that outreach resulted in no interest from any parties in providing alternate DIP financing proposals.
Let me ask you one last question. I've already approved the timeline, right? In terms of when, so we're coming back on June 26th for plan confirmation. Are you aware of any potential better deal that could arise between now and June 26th?
No, Your Honor, I am not.
Do you believe that the estate has negotiated what it could under the circumstances, or do you believe that the estate can negotiate a better deal?
I believe that the estate has negotiated the best deal possible.
Why do you say that?
The deal is a product of extensive negotiations with the ad hoc group of lenders over the course of several months. Further to that, the deal is open to all lenders. The deal is open to all lenders. Further to that, the DIP is open to all lenders. And the deal right now, as you've heard the Latham and Watkins folks refer to, has 100% support as it relates to the RSA. Further to that, has a 100% participation, from our understanding, as it relates to the funding of the DIP itself.
Thank you. Mr. Ruff, do you have any questions?
Yes, I do. Thank you. Again, good afternoon. Jason Ruff with the U.S. Trustee's Office. I'll ask the same question I asked of the prior witness, and that's, do the debtors require the repayment of these pre-petition amounts that are proposed in the interim DIP order to help avoid immediate and irreparable harm between now and the final hearing?
So the terms of the restructuring itself is a package deal being implemented via the plan of reorganization as well as the DIP. So again, as I alluded to earlier, was a product of extensive negotiations. The DIP, the plan of reorganization, and all the terms therein are part of a package deal that was negotiated with the lenders.
If a committee were to be appointed in these cases, and a committee was able to successfully challenge, as provided for in the proposed order, what would be the benefit to the committee in your mind to successfully mounting a challenge if it's not able to unwind some of these payments that are made in the pre-petition period?
Sorry, would you be able to repeat the question?
Yeah, I'll try to be a little more succinct. What value do you think it would be to an unsecured creditors committee to successfully mount a challenge as authorized in this proposed order to its constituents?
I am not aware of any benefit, and right now the deal as contemplated with 100% support contemplates all unsecured being paid in the ordinary course.
Would you agree then that a challenge in this case then would really be superfluous if it's not able to unwind these pre-petition amounts that are being repaid?
Yes.
No further questions, Your Honor.
Okay. Thank you. Mr. Gott, what else do you have? Anything else?
Well, Your Honor, if you'd like me to walk through the sort of legal points that we think justify the refinancing, I think those would be important to put in the record. We did make the points in our motion, so if Your Honor has read the motion.
I've read the motion, but if you want to highlight some points, I'll certainly give you the opportunity to do so.
Great. Thank you, Your Honor. The first point, and frankly one of the most important points here, is that these facilities were issued under the 2019 confirmation order from the debtor's prior Chapter 11 cases. And based on the language that's in the order, we just really don't see a way for a challenge to be successful without effectively collaterally attacking that order. And so we think that is a potentially insurmountable hurdle for anyone who would otherwise be interested in posing a challenge. And that's even setting aside the fact that we've found no material problems with the lender's collateral package. The second point I'd make is these exit facilities are super senior under an intercreditor agreement with the takeback lenders. And by any reasonable measure, the debtor's assets greatly exceed the $300 million of that super senior debt. So not only would a challenger have to overcome the 2019 confirmation order, but there would have to be a massive issue with perfection of the exit facility liens to leave those lenders undersecured and make a challenge worthwhile. Your Honor heard the plan, of course, that we have is, if confirmed, will leave unsecured creditors unimpaired or paid in full. So there's really every reason to expect that no committee will be appointed. The 100% support we have from our takeback lenders suggests there's every reason to believe the plan will be confirmed. And what's more is that not only are unsecured set to recover in full at the end of the case, but the first day relief that's been granted here today is going to result in a majority of those same creditors getting paid soon, in between now and confirmation. I'll note, and as set forth in our pleadings, this DIP facility is actually cheaper for the estates than leaving the exit facilities outstanding and accruing default rate interest, not to mention involving another set of professionals on behalf of those exit facility lenders, fees that the estates would have to bear under the applicable credit documents. You also heard from the witnesses that this refinancing is a basic building block of the DIP, and the DIP is essential to the RSA. So without the refinancing, Your Honor, we may not have the RSA or the plan. Sitting here right now, we don't have consent from the exit facility agent to its liens being primed, as would otherwise be contemplated by the proposed order. And that could lead to issues with milestones, with RSA compliance, and it would put us all back at the drawing board at precisely the worst time. I'll also note that many of the RSA takeback lenders also have holdings in the exit debt, so it's very much the case here that the expectation for everyone who signed up to the RSA is that this refinancing would happen. It would happen this week, and that payment would be indefeasible. The last note, Your Honor, is that as far as precedent goes, in another recent prepackaged Chapter 22 in this district, in Avaya, the U.S. trustee raised the same objection to the interim DIP order there, and that objection was overruled. So, Your Honor, that's really the points I wanted to make in summary. I think the key thing here is, if we don't have a DIP ready to go if the refinancing is not going to be approved on the terms in the order. And that would be really disruptive to a process that's otherwise completely smoothed over with a clear pathway between here and confirmation, unsecured creditors being unimpaired, and 100% unanimous consent from the one group of creditors that is going to be impaired.
Thank you. Mr. Ruff?
Again, thank you, Your Honor. Jason Ruff for the U.S. Trustee's Office. I hear everything that debtors are saying, and we did talk a lot about this, more than what we usually talk about things over the weekend. The concern we have is that if everything goes according to plan, then what the debtors are telling you is true. But we're not across the finish line yet. We have a plan. We have an intended path that the debtors want to go down. And assuming everything goes as intended, then we're not going to have an issue here. Our role as the U.S. Trustee's Office is to try and protect people's due process rights. We may or may not have a committee in these cases, but we have the duty to solicit for a committee under the code, and so we do that. And creditors have the choice to say, yes, we do want to be on a committee, or they can choose to accept what debtors are telling them and say, we don't see a benefit, and no, we don't. If they are on a committee, Your Honor, our objection, to be clear, is not to the payment here, repayment in the interim period. Our objection is that there are certain challenge rights that are afforded rightfully to a committee under this interim order. The debtor's testimony, or the debtor's representative's testimony, was that a challenge would essentially be superfluous to the benefit of any creditors committee if they were successful, if they're not able to undo these repayments of pre-petition amounts. And what the debtors have argued here today, as far as, well, these were terms that were approved by a prior bankruptcy, those all sound like great defenses to a challenge, but nevertheless, a party should be afforded to make the challenge. And if they're able to overcome whatever objections that the debtors raise to those, then they should be able to have some rights. Otherwise, they're going to be really with no teeth and no ability to do anything, even if they're successful. So, again, Your Honor, we think due process requires that if Your Honor is to approve this financing today, then with the challenge rights for them to mean anything, they should be, these repayments should be subject to any successful challenge that at least is made in the interim period or prior to the actual approval and confirmation of this plan. So that would be our objection, Your Honor.
Thank you. So before the court is a request for the debtor to enter into post-petition financing and to utilize cash collateral to grant adequate protection to secured parties. The court has considered all of the argument, and I take close consideration of the declarations that were filed, and I do appreciate that declarants, two of the declarants, were able to kind of provide some additional color to the court. I'm going to overrule the U.S. trustee's objection. I'm going to grant the motion. I'm going to express my reasons why. One, it's clear that the debtor needs the financing. I think Mr. Kuh's declaration shows the debtor needs the financing to be able to continue to operate during these cases. And you look at the debtor's cash position and what has been proposed in the plan, which is to unimpair unsecured creditors and to pay certain of them in the ordinary course of business and to pay employees. It'll require a significant amount of money between now and plan confirmation. And so there is a need for financing. And so the requirements of Section 364 have all been met. Now, kind of getting into the heart of the trustee's objection as to whether essentially the takeout is required at this stage. I will tell you, I understand it's been done in another case, but the precedential value of that, I understand why people cite it, but every case is viewed differently on its own terms, and so I know Judge Jones would find something that I would find it interesting, but it wouldn't it wouldn't sway it one way or the other. I think every case is its own set of facts, and so I really look at kind of what the code requires, and I think Mr. Carter really got me over the edge. This has been shopped pre-petition a lot, and the debtor tried to come up with different forms of financing, and I've got a very well experienced and well respected professional telling me that this is the best deal, and not aware of any other deal between now and the time we get the plan confirmation. So one can, and the debtor has the ability to pay unsecured creditors in the ordinary course of business. And I think Mr. Gruff is right. Who knows if there's going to appoint a committee, and that's not my business. And folks may choose to serve on a committee. And so I really care deeply. But I've got a proposed plan that will unimpair unsecured creditors and pay them in full in the ordinary course of business. I've got a professional. I've got the debtor telling me that they're unaware of any other deal and that they've really worked hard to get the deal, and I believe that they did, and I believe that that's the testimony that tips it over for me. I do think every case is different, and I really do stress, and the United States trustee will be right to object in the next case, and I think in the case after that, I think every case is different. In some case, the answer may very well be no. But based on the facts that we have here, based upon the testimony that I have, based upon the circumstances of this case, I'm going to overrule the trustee's objection, and I'm going to grant the motion. Where do we go next?
Yeah, Your Honor, just before pushing the button on approving the order, we do have some dates to fill in at the very back of the order, which we propose to have the final DIP hearing at the same time and place as the confirmation hearing.
Yeah.
And the objection deadline to run at the same time as for the other first day motions.
Yeah, I am going to add that, I believe it's in paragraph 37, June 26th right, at 1 p.m., objections June 6th at 5 p.m.
Thank you, Your Honor.
All right. Where do we go next?
Objections. I think the objections are the 16th, Your Honor.
I think it's the 16th for your plan confirmation, but the 6th for the kind of interim orders.
Oh, yes. That's correct.
All righty. Where do we go next?
You can hear me, Your Honor, right?
Mm-hmm.
Okay. Nothing else, Your Honor. Again, thank you very much. I appreciate your words earlier. I do want to echo you're only as good as the team around you, and the team has worked incredibly hard. I hope you saw that in all the documents in today, and I appreciate your time, the trustees' time, the clerk's time in reviewing a lot of documents as thoroughly as you did, and we truly appreciate it.
Alrighty. So when shall we meet again? I guess we're coming back in about a couple of weeks to see where we are, and. But nothing else, I thank everyone. There may be some folks who are showing up for a 4 o'clock hearing. There have been some recent filings in the 4 o'clock hearing case, and I want to take some time and read them. So I'm going to start the 4 p.m. hearing at 4:30 p.m. I will post a note on GoToMeeting, and I'm going to figure out how to do that, and maybe share my screen with a blank piece of paper saying the hearing will start at 4:30. But I thank everyone in the Monitronics case for their time, and everyone is excused. I'm just going to sit here and type a one-pager. Thank you.